So, when it comes to criminal law, where's that line? You know, the one between just thinking something bad and actually doing something criminal? Well, it all hinges on what's called the ACT requirement. And today we're going to break this whole thing down. Trust me, it's way more interesting than it sounds. Let's just jump right in with the big question. Can you actually be arrested for just thinking about committing a crime? I mean, really. The answer in our legal system is a hard no. But the really interesting part is why not? And where exactly does the law draw that line between a thought and a crime? Let's dig in. All right, here's how we're going to tackle this. First, we'll cover the basics, thinking versus doing. Then, we'll get into what makes an act voluntary. After that, we'll look at what happens when your body acts without you. And believe it or not, we'll even cover when doing nothing at all can be a crime. Finally, we'll look at where that duty to act comes from. Okay, section 1. Let's start with the absolute foundation of all of this, the huge difference between just thinking about something and actually doing it. So the law loves its Latin, right? The term for this is actus reus. It literally means guilty act. Now, you've probably heard of its famous partner, mens rea, which is the guilty mind. Well, actus reus is the other half of the puzzle. It's the physical piece, the actual action, or as we're going to find out, sometimes the inaction. And this quote really nails it. It's a core idea in our legal system. You just can't commit a crime with bad thoughts alone. I mean, think about it for a second. How could a prosecutor possibly prove what's going on inside someone's head? It's impossible. But just as important, we want to give people a chance to back away from the edge, right? To have that bad thought, but then choose not to act on it. Okay, but here's where it gets a little tricky. We say thoughts aren't punishable, but what about speech? Spoken words are a different ballgame. And why? Because speaking is a physical act. You're actually moving your tongue and vocal cords to make sounds. That physical action is why something you say can absolutely be the guilty act needed for crimes like perjury, or trying to hire someone to commit a crime, or conspiring with someone. All right, moving on to part 2. So we've established we need a physical act. But wait, there's more. It's not just any act. The law says it has to be a voluntary one. And what does voluntary mean here? It means the movement has to be a product of your own free will. You decided to do it. Think of it this way. If someone physically grabs your arm and uses it to hit someone else, sure, your arm moved. But did you act? Nope, that wasn't your choice. Now, this might seem kind of obvious, right? Of course it has to be voluntary. But let's ask why. Why is the law so insistent on this point? Well, it gets right to the heart of what the criminal justice system is trying to accomplish. And it really makes a ton of sense when you break it down. Think about deterrence. How can you deter something a person can't control, like a seizure? You can't. And retribution, or punishment. It just doesn't feel right to punish someone for something their body did without their permission. And finally, rehabilitation. If someone has a medical condition that causes involuntary movements, that's a problem for a doctor, not a warden. Okay, section 3. So what counts as involuntary? This is where we get into some really specific and honestly kind of wild scenarios where the body basically acts on its own. To get a handle on this, a lot of states look to something called the Model Penal Code. It gives us a pretty clear list. We're talking about a reflex, like pulling your hand from a hot stove, a convulsion, any movement you make while you're unconscious or asleep. Even, interestingly, actions taken under hypnosis. And that last one is a big catch-all. Basically, any bodily movement that isn't something you consciously decided to do. The classic textbook example is sleepwalking. If someone harms another person while they're sleepwalking, the law says that's not a voluntary act. Their conscious brain just isn't at the wheel. The exact same thinking applies to, say, an epileptic seizure. No voluntary act means no crime. But, and this is a huge but, it's not always that simple. The law is pretty clever, and it knows how to look for loopholes. So even if the final harmful act was involuntary, the court is going to look back. It's going to ask, okay, but was there an earlier choice, a voluntary act that put this whole dangerous situation in motion? And the sleepy driver is the absolute perfect example of this. So think it through. The driver starts to feel dangerously drowsy. That's step 1. But then, and here's the key, they make a conscious, voluntary choice to keep driving. That's the voluntary act. Then they fall asleep, which is involuntary, and cause a terrible crash. So where's the crime? It's not the falling asleep. The crime, the actus reus, is the voluntary decision to keep driving when they knew they were a danger.
All right, let's switch gears completely for section 4. Up until now, we've been talking about actions, doing stuff. But what if I told you that you can actually commit a crime by doing nothing at all? Welcome to the law of omissions.
So, here's the basic breakdown. Most crimes are what we call crimes of commission. That means you committed an act the law forbids. You did something. But a crime of omission is the opposite. You're liable because you failed to do something the law specifically says you have to do. Now, this is a really, really important point. The law does not punish you just for having bad morals. In most of the US, you could literally stand on a pier and watch a stranger drown, and you would have committed no crime. Morally, that's awful, of course. But legally, criminal liability only attaches if there was a specific legal duty for you to act. Just feeling like you should do something isn't enough. Which, of course, leads to the next big question. Okay, if a moral duty doesn't count, where do these legal duties come from? How do you know if you have one? Well, the law generally points to 5 main sources. So here they are. First, a duty can come from a special relationship. Think parent and child, or spouses. Second, a statute. A law on the books can create one. Think of tax laws or hit-and-run laws. Third, a contract. A lifeguard on duty is a perfect example. Fourth, if you voluntarily assume care for someone. Basically, if you start a rescue, you can't just walk away. And finally, if you create the peril yourself, even by accident, you have a duty to help. And let's make this real with some examples. For relationship, a parent failing to get medicine for their sick child. That's a breach. For statute, a driver who doesn't stop after an accident. That's a classic. For contract, an on-duty lifeguard who just watches a swimmer struggle. For assumption of care, imagine you start pulling someone off train tracks but then just leave them there when you could have finished. And for creating the peril, if you injure someone, you can't just leave them in a dangerous spot. In every single one of these situations, doing nothing is the guilty act.
So, let's wrap this up. The big takeaway here is that actus reus is like the bouncer at the door of the criminal justice system. You don't get in without it. It's the principle that ensures we only punish people for a voluntary physical act or for failing to act when the law says they absolutely had to. It's that bright, clear line between just a thought and an actual crime.
But I want to leave you with one final question to chew on. The rule in the US is pretty clear. No general duty to rescue a stranger. But that's not true everywhere. A lot of countries have what are called Good Samaritan laws, which actually make it a crime not to help someone if you can do it without putting yourself in danger. So it makes you wonder, should our laws change? Should we impose a legal duty to be a Good Samaritan? It's a huge debate, and it really gets to the core of what we think the law should be doing.